Hello and welcome to this session in which we will discuss defenses for the surety. Now, who's the surety and what role do they play? Well, the concept of suretyship involves three parties. We have one party, that's the creditor, that's going to lend money to someone else who's the debtor. So the creditor gives money to the debtor and the debtor expects to pay back the money plus interest. But sometimes the creditor don't trust the debtor. So they ask the debtor to ask for another individual or another party or another company to guarantee the debt. This party is called the surety. Surety is making sure that if the debtor don't pay, the surety will have to pay. Now, the question is, what happens if the surety doesn't want to pay for one reason or another? Do they have any defenses to get out of this obligation? Because the surety agrees to be responsible for this debt. Yes, there are several defenses that a surety can use to avoid this liability. And in this session, we would look at these defenses. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com. Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today. One of the defenses is where the debtor was tricked into this loan by the creditor's fraud. What does that mean? It means when the loan occurred, when the creditor gave money to the debtor, fraud was involved. So somehow the creditor tricked the debtor into taking on this debt. Now, after they take on this debt, they brought the surety. So the surety could use this as a defense, the fact that the creditor defrauded the debtor. Now, bear in mind, if the principal debtor committed fraud without the creditor's knowledge, that does not protect the surety. In other words, if the debtor committed the fraud, if the person borrowing money, let's assume they put the wrong information on their application. As a result, the creditor granted them money. That's fraud. Well, the surety guaranteed the debt of the debtor. Well, the surety cannot get out of the deal because the debtor acted in bad faith and the surety is backing up the debtor. However, if the creditor, I want to make sure you understand this, if the creditor committed the fraud and tricked the debtor into borrowing the money, then the surety will have a defense. So if the principal debtor deceives the surety, lies about their financial status, the surety cannot use as a defense against the creditor unless, now bear in mind, unless the creditor knew about it. If the creditor knew about this, it means the creditor and the debtor now, they're trying to defraud the surety and the surety will have a defense. But if the creditor is not aware of it, well, the creditor was deceived as well because the debtor deceived both the creditor and the surety can't do anything about this because when a person asks you to co-sign, it means they don't have good credit. There's something wrong with their credit. They either have no credit, it means they lack of a credit history, or in the past they have lousy credit. In other words, they're not responsible. So you have to be very careful when you co-sign a debt for someone. If the principal debtor was forced into a contract under duress, that's also a defense. So if the principal debtor, the person that borrowed the money, was coerced into the contract and the surety was not aware of this coercion, then the surety may not be liable for the may not be liable. Why? Because the original contract was void. It was under duress. If the contract between the creditor and the debtor is illegal, what does that mean? It means that the loan is of illegal nature because of a gambling debt or maybe a drug deal. Well, the surety that cannot be held for that because the contract itself is illegal. So if the surety goes to the court and says, well, guess what? This contract is illegal, then the court would relieve them from this responsibility. Other defenses if the debt is settled or the principal debtor offers to fulfill their obligation and the creditor refuses. So if the person that borrowed the money says, I'm going to pay you back the money to the creditor, well, then the creditor can no longer go after the surety. The surety is released from the liability because the original debtor is willing to pay the money. Also, if the creditor forgives the principal debtor, the surety is discharged unless the creditor explicitly retained the right to go against the surety. So if the creditor tells the debtor, look, you are forgiving, I'm done, you don't have to pay me back, the surety is off the hook. However, if the creditor says, you are off the hook, but I'm going to go after because you cannot pay, I'm going to go after the surety, I'm going to reserve that right, then they can reserve that right. If the surety is legally incapable, notice the surety themselves, the person that made the promise to co-sign the loan, to pay back the loan in case the loan wasn't paid back, if they are legally incapable of entering into a contract because of their age or their mental capacity, or they are bankrupt, those can be used as a defense. Now bear in mind, the person making this promise to pay is incapable. Now, the surety remain liable to the creditor if the principal becomes bankrupt. Of course they will. That's why they became, that's the risk that they took when they took over the suretyship arrangement. So if the principal debtor became bankrupt, the surety is still responsible. If the principal debtor is legally incapacitated, like mental incompetent, the surety is still responsible for this debt. A surety must have a valid consideration to be legally bound. Now, valid consideration, it does not mean they need to be paid. They need to receive payment. You could have a surety that's done out of good heart. For example, you could have a gratuitous surety, which is unpaid surety, and this is usually between family members. Now, this will bound the surety as long as the promise is made before or simultaneously with the creditor's obligation. Let's take a look at an example for a gratuitous surety. Consider a father who promises to be the surety of his daughter's student loan. The promise would be considered valid consideration if the father makes this promise before or at the same time the bank agrees to grant the loan to the daughter. However, if the father makes the promise after the loan was already made, the promise lacks consideration and it's not enforceable. Can the status of the surety changes if there's any changes in the original contract between the debtor and the creditor? Yes. The surety's liability, the person that's, co-signing the loan, their liability could change if the original contract between the debtor and the creditor changes as well. And the impact of these changes depending whether the surety is paid or whether the sureties is unpaid. Remember when we said unpaid, it means gratuitous surety. So I'm just going to say paid or unpaid. If the surety is unpaid, any change in the contract that changes the risk assumed by that surety, by that unpaid surety, it would release them from their obligation. This is because the agreement was based on specific term and the risks of the original contract, and now it changes. It doesn't matter whether the risk went up or the risk went down. Any change would relieve unpaid surety from their obligation. For compensated surety, for surety who are paid, a variation in the contract only discharge them if the change significantly increased the risk of loss. If it significantly increased the risk of loss, they are off the hook. So minor changes that makes the principal obligation easier to fulfill do not release a compensated surety from their obligation. Sometimes they might change the contract where it's easier for the surety to comply. Let's take a look at an example. A principal debtor is contracted to deliver 100 units of a product to a creditor. Well, an unpaid surety guaranteed this obligation. Great. Later, the principal and the creditor agree to increase the order to 150,000 units. This change in contract will discharge an unpaid surety, as the risk they agreed on is to cover 100,000. And the same would be true if they change it to 80,000. Just not because they increased it. However, if the surety was a compensated one, they would only be discharged if the increase in quantity significantly raises the risk of default or loss, which may or may not be necessarily in this case. So is an additional $50,000 significant increase? It depends on the circumstances. If the answer is yes, then that says the compensated surety is off the hook. If not, they are still on the hook. Other changes in suretyship. In suretyship, certain actions or inaction can affect the obligation of the surety, especially when it comes to extension of time, loss of security, which is the collateral, and release of a co-surety. Let's take a look at each one of them separately. Extension of time versus delay in collection. If the creditor and the principal agree to extend the time of the payment, if the surety is unpaid, that's it. They are discharged. Again, the terms changed, therefore they are off the hook. If it's a compensated surety, if it's a paid surety, only if the risk has changed, the risk has increased substantially. Only if the extension materially increases the risk. How about delay in collection? If the creditor simply delays in collecting the debt without formally extending the due date, neither the unpaid or the paid sureties is discharged. It's simply they're giving them more time to pay. That's fine. How about loss of security? Loss of security. Loss of security means we had a collateral in the deal and now the collateral is gone. If the creditor releases a security without the surety's consent. So when the deal was originally signed, the debtor promised to put up a warehouse or his house or his office building as a collateral. Now the creditor says, you know what? I'm gonna remove this from the deal. I'm gonna remove this obligation. Well, the surety is discharged to the extent of the value of that security. So if the loan was $1 million and the surety was guaranteeing $1 million, part of that $1 million was a $600,000 building, and now the creditor says to the debtor, you know, that building is off the deal, off the hook. You know, take it from the contract. It's no longer a security for me. I agreed that I relieve you from this obligation. Well, if you relieve the debtor from the $600,000, now also you have to relieve the surety of that $600,000. Therefore, the surety is only responsible for $400,000. If the security is lost due to the creditor's negligence, let's assume it's a vehicle. So simply put, the debtor did not secure it. The security is discharged up to the value of the lost security, unless protecting the security required substantial and burdensome effort. Simply put, if a security is lost, again, the surety is discharged up to the value of that security. What about the release of co-surety? Because remember, we could have more than one surety. We could have a co-surety as well. If the co-surety is released, if one of them is released without the consent of the other ones, the remaining co-sureties lose the right to claim back from the released co-surety, of course, because they're released. They are also discharged to the extent they could have claimed from the released co-surety. So since they cannot ask them for contribution later on, they will be released from covering their debt as well, or the responsibility of the debt as well. Let's take a look at an example. Let's say a company named Bolt borrows $100,000 from a bank and two co-sureties, Bear and Gear, each responsible for $50,000. Later, the bank decides to tell Gear, you know, you're off the hook. You don't have to be a co-surety without Bear's consent. So Gear is out. Subsequently, if Bolt fails to repay the loan and the bank turns to Bear for the $100,000, in this situation, Bear is only responsible for $50,000 because the bank relieved the other co-surety without their consent. So Bear is discharged from the responsibility of the other $50,000, which could have been Gear's share due to the loss of the right to seek contribution from Gear. Because if they pay the $100,000, they cannot get their money back, which is called contribution from Gear. What can debtors do other than filing for bankruptcy? Let's take a look at a few options. When a debtor finds themselves unable to pay back a loan, well, they can go into what's called creditor's compensation, or they can go into assignments for the benefit of the creditor. So we need to be familiar with those two options. What's creditor's compensation? It's a negotiation between the debtor and at least two other creditors. Now, why two others? You're going to see why. In this arrangement, the debtor agrees to pay the creditor a portion of the total amount assumed instead of the full amount. So what do? You talk to all the creditors. If it's one, it's You just basically, it's forgiveness. But if there's more than one, you will say, okay, I have all these stats. Let's work a deal all together. It's for the benefit of all of us. So let's think about Jane. She owes $10,000 for A and B, but she's unable to pay the full amount. So what she does is she can propose a composition where she agrees to pay $6,000 to each creditor in full settlement. So she got $12,000. Okay, both creditors will agree to accept this lesser amount because the $12,000, if she decided to pay A for the full amount, B will only get $2, and vice versa. So what they would do, Jane will do, is will say, okay, let's have a deal. I'm willing to pay $6,000 for each and call it for the day. Both creditors will agree to accept this lesser amount, understanding they're better off to get a reduced amount rather than potentially nothing at all. So once Jane's pays that $6,000 to each, her debt to the creditors, A and B, is considered fully settled. So she won't owe them any more money for those particular debt. So this is called creditors' compensation. So creditors' compensation, they all agree, we're off the hook, we're done. So she negotiated with the debtors. Something else that the debtors can do is assignment for the benefit of the creditor. How does that work? This process is where the creditor hands over some or all their property to a trustee, a lawyer, a judge, whatever, a bank, someone. The trustee then sells this property and uses this money to pay off the debtor's debt. Let's say John has debt he cannot pay. He transferred his car and some valuable art to a trustee. The trustee sells them for a total of $15,000 and uses the money to pay John's creditors. However, if the total amount is $20,000, there's still a $5,000 shortfall. Now, unlike credit composition, this method does not fully discharge the debtor's obligation. Remember, if there's still unpaid debt after the property is sold, John still owes this amount, the $5,000. In contrast to the creditor's composition, once you are done, once you are settled with them, the debt is settled and all is gone. Let's take a look at this multiple choice questions from Farhat lectures. What defense can a surety use if the principal debtor deceived them into becoming a surety? Should the debtor deceive the surety? Well, let's look at D. The surety is automatically discharged from their obligation. This is an easy answer, but the answer is wrong. The surety, actually, they're not automatically discharged, although they were deceived into becoming a surety. A, the surety can always use this as a defense against the creditor. Basically, A and B are the same. They cannot use it against the creditor because the person that deceived them is the debtor. Remember, the debtor deceived them, not the creditor. They cannot say, well, I'm not going to pay. The surety cannot use this defense. Well, under some circumstances, they can. The surety can use this defense only if the creditor was aware of the deception. Now, if the creditor was aware of the deception, then now it's the creditor and the debtor, they both are deceiving the surety, then the surety can use this as a defense. So be careful. They can use it as a defense if if the creditor is aware. Because if the debtor deceived them and creditor is aware, they're both of them trying to deceive the surety. Therefore, they can be off the hook. They can use it as a defense. What should you do now? You want to go to Farhat lectures and look at additional MCQs. That's going to help you whether you're studying for your CPA exam or your business law. Invest in yourself. Study hard. The CPA exam is worth it. Good luck, and of course, stay safe.